女士们、先生们，大家早上好！香港法律周2024第4天的活动即将开始，请各位尽快就座，并将手机和电子设备调校至静音模式。多谢合作。同时，我们也欢迎线上收看的观众同步参与活动。今天的节目将以粤语、普通话及英语进行，并设有普通话、粤语及英语的即时传译服务。在场人士如果需要即时传译服务，可以移步到会场入口处的服务柜台领取耳机。如果您现在需要耳机，也可以举手，我们的工作人员会向您提供耳机。频道1为英语，频道2为粤语，频道3为普通话。谢谢。Ladies and gentlemen, simultaneous interpretation services in Cantonese, English, and Putonghua are provided. Should you need SI headset, please kindly collect it at the registration counter at the entrance of the hall. Please tune to Channel 1 for English, Channel 2 for Cantonese, and Channel 3 for Putonghua. 现场同步的与会者亦可以直接点击屏幕上显示的频道去选择相关的语言。第4天的活动即将开始，敬请期待，谢谢。
Ladies and gentlemen, distinguished guests, good morning. Welcome to the event that is hosted by DOJ. Welcome every one of you, either in person or online. Thank you for your support. First of all, let's invite Secretary for Justice, Hong Kong SAR of the People's Republic of China, the Honorary Paul Lam Ting Kwok, SBSC JP, to deliver his opening remarks. Let's welcome Mr. Lam. Distinguished Mr. Ting, Ms. Leung, friends from Mainland China, dear guests, good morning. Welcome every one of you to our annual flagship event, Hong Kong Legal Week Day 4, especially for those who come from GBA and other Mainland China cities, and friends from legal practitioners, and as well as our peers from Macau and overseas. Very happy to be here to discuss a joint contribution to the construction of rule of law in the GBA. GBA is a most open, most vibrant region in China. In our national development, it holds a strategic position. We need to unleash the development potential. And of course, we need to have the rule of law in place. As President Xi mentioned, rule of law is the best business environment. Hong Kong has very clear rule of law system and our common law, transparent legal system, and professional legal professionals. These are our proud advantages. And for GBA's law integration and law construction, I'm sure we can make contribution. In April this year, DOJ issued the action plans. We proposed 3 connection to region and also 1 GBA. We'd like to do it through law regulation alignment and talent cultivation. We hope to give full play, give advantage to each jurisdiction, and we can together build a greater Bay Area. Today, the theme is joint contribution to the construction of rule of law in the GBA. I'd like to share how we deliver changes to adapt to the GBA construction. First of all, joint contribution, it means we can coordinate the rule of law and rule system within GBA. Together, we can grow. We have 1 country, 2 system, 3 distinctions. We have different legal systems in this region, so we need to resolve the differences and build the gap, bridge the gap. We need to transfer the unique characteristics of different jurisdictions into our economic growth. We're very happy. In early last year, Mainland China and Hong Kong signed CEPA Service Agreement revised version. We support Hong Kong companies to take jurisdiction here. And DOJ will try our best to complement or implement this practice. We also would like to expand this initiative into 9 cities in Mainland China. Relevant initiatives, it shows these are very critical parts for Mainland China enterprises to go abroad with Hong Kong as a springboard. Vice versa, we serve as a springboard from overseas companies into Mainland China. In practice, Hong Kong enterprise and Hong Kong law it's very relevant to legal practices and framework. So we need to have a very clear framework to give full play to this whole unique characteristics. And we are very happy to have Mr. Chen, Department of Justice of Guangdong Province, and also the judge from the Guangdong Province. Later, we will have keynote speech, and also we have lawyers from Mainland China and Hong Kong to do the thematic dialogue. They will share their experience and how Hong Kong can help to solve the cross-border legal cases. Mainland China and Hong Kong established a comprehensive mechanism through active alignment and also sharing the best practices. Now we have 9 laws. We will tell the details about how to do the bankruptcy or how to do the evidence proof taken, etc. We'd like to facilitate all the cross-border commercial transactions and protect the legitimate rights and interests of each party. We are very happy to have Ms. Kwang, judge from Hong Kong High Court. And we also have a lot of legal experts. They will share their view from judge or from barrister, from solicitors. They will share their experience. I believe it will help you a lot in understanding different regulations and practices. We will also perfect the existing system. For example, optimize the document delivery between China and Hong Kong to better serve the people in different regions. We will also coordinate when we give full play to our advantages. We want to push the rules or regulations alignment for certain laws. I think this platform is a very good example. It's a perfect product, and with the support of the joint effort from 3 governments, we have the arbitration assessment standards. We also have the best practice in terms of cross-border dispute resolution through the standardized mechanism. I think it will lay a solid foundation for the mechanism foundation. And this afternoon, we will take the mock court to present this mechanism to you. Mainland China, Macau, and Hong Kong's dispute resolution experts through mock dispute court regarding a cross-border good transaction. They will give us an explanation, a showcase, telling us how the 3 regions can turn the differences within the 3 regions into advantages. And the last 2 words is change. And first of all, change means we need to have the bravery. We need to be innovative to adapt to the new challenges and trends. No matter it's a one country, 2 system, GBA construction, or Belt and Road initiatives, there's no precedent. These are very groundbreaking, innovative, and with Chinese characteristics. As Chief Executive said in his delivery, he said we need to pursue changes with the technology advancement. The law field need to catch up. So we will also establish a panel to make technological policies to push the development of new quality growth. We need to use law tech to be more competitive. And most importantly, DOJ want to establish a consultation platform for GBA region. We gather people from different backgrounds in the legal realm. Just as today, it served as a platform for people to gather here, think together, exchange views. We encourage more consensus to lay foundation for the next step cooperation. And we would like to contribute to the more systematic development of GBA. GBA has a very good legal mechanism. I'm very happy in GBA Development Action Plan after 5 years of its initial launch. I'm very happy to be here with all of you at Legal Week 2024. And in the spirit of innovation, we'd like to push the legal cooperation within GBA region. I look forward to the sharings of all the speakers, and I hope every one of you here can benefit from this event. Thank you. Big round of applause for Mr. Lam. Thank you for your opening remarks. Please be seated. Thank you for the opening session regarding the joint contribution to the construction of rule of law in the GBA. And also, Mr. Lam just alluded to the speakers. Now, let's welcome Mr. Cheng Xudong, Director General of Department of Justice of Guangdong Province. Big round of applause for Mr. Chen. Mr. Lam, Ms. Learn, peers from Macau, Hong Kong, and Mainland China legal fields, friends from the media, good morning. At this beautiful time, I'm very happy to be Hong Kong again with friends from legal realm. I'm happy to discuss GBA's construction. This is an important topic. On behalf of Guangdong Department of Justice, I'd like to congratulate on the successful holding of today's event. And for those who have supported legal construction for a long time, thank you so much, my dear friends. Construction GBA is Mr. President Xi's baby. Recent years, Hong Kong, Macau, and Mainland China have cooperated closely in different fields. The soft connectivity is speeding up, especially in legal affairs. The governments work together, hand in hand, through rule alignment, mechanism alignment, a little bit of everything. We'd like to make the perfect law system. We have better improvement and better situation. We pay great attention to the connectivity. We established new mechanism. Recently, the legal departments within GBA region, starting from 2019, we have hosted 5 times of the joint conferences. For 3 regions, we work together, and next year it will be our 6th time. And next month, it will be hosted in Guangdong. We also have Guangdong Cooperation and Dispute Resolution Office. We also have mediation work panel, also have the conference for GBA lawyers. that meeting is more frequent, and the mechanism is gradually being building up and running smoothly.
促进法律协同。
So in order to promote the synergies between the legal systems in the three regions, this July, as witnessed by the governor of the Guangdong province, as well as the CEO of Hong Kong, the Guojing vice mayor and I signed a special arrangement on the exchanges between the Guangdong Justice Department as well as the DOJ in Hong Kong. We believe that this agreement will definitely help to grow even in-depth cooperation between Guangdong and Hong Kong and start a new chapter. We will definitely dedicate ourselves into the in-depth cooperation, and we will witness new opportunities in the region. Last year, we had got the successful extension of the pilot program of lawyers in the Great Bay Area, and this year we will continue lowering the entry barrier so that lawyers in Hong Kong and Macau can practice in Hong Kong and vice versa. So we will go on reviewing the program and keep improving so that we can carry out this innovation program continuously in the future. Currently, over 500 lawyers in Hong Kong and Macau have got their licenses in the Greater Bay Area for practice, and you can see it has a great significance. More and more lawyers from Hong Kong and Macau are now going up to the stage of the Greater Bay Area and give full practice of their expertise. This September, the Guangdong People's Conference made a very important decision on enhancing the legal services in the Greater Bay Area so that we can work on the international affairs and as well as distribution resolution. We also support that the Hong Kong businesses, Macau businesses, as well as Greater Bay and Guangdong provinces businesses to choose Greater Bay Area as the resolution destination. And in this way, our business environment will be even more stable and more transparent. We enhance the exchanges on personnel and dare to undertake new missions. So last month, we held the second Greater Bay Area legal person training on the 20th to the 22nd. The first session was held in Macau, which we received very good feedback. And this year, it was held in Guangdong. Our legal cooperation between the three regions are going even more in depth. At the same time, with the combined effort and participation from the three regions, the RCA conference for 2024, as well as the Greater Bay Area Legal Forum, together with the Legal Service Forum and the Chinese-speaking lawyers conference for 2024, were held successfully. And the legal education and training is also helping the businesses in the regions to go global, particularly along the Belt and Road countries and the regions. So those are the important and very hot topics, and they have attracted a lot of attention. Around those topics, we have reached consensus and agreements, and we are committed to utilize our wisdom and power to write an even better chapter in the Greater Bay Area legal construction. As put forward by President Xi Jinping, we have the requirements on the 1.2 region, two regions. I must say that soft connection between the regions are even better. We have the Hong Kong-Zhuhai-Macau Bridge, which is a hard connection. we have soft connections through our services as well. So we need rules, we need mechanisms, we need soft connections, some soft mechanisms. So we believe that they will also play a very important role. Looking back, we have made a lot of progress, and in terms of legal construction in the region, we have been working steadily and solidly, and we never expect too high, and we never pursue the unrational results, and we just make solid steps forward. And sometimes, even though it could be a small matter, however, they can be very effective and have a great significance, just like mediation. So in the Greater Bay Area, mediation is something that we can reach consensus on in the easiest way. The legal cooperation between the cities in the region will definitely go better because we have a lot of similarities. So through a small step, we can achieve great effect. So based on the theme of the forum today, I want to share with you 3 of my thoughts. First of all, we must understand our strategic positioning under the changing context, because the only thing that doesn't change is a change. The biggest feature of the world is change. We have to adapt ourselves to the changes and promote and deepen reforms continuously. I think that the critical point about legal construction in the region is integrate ourselves into the macro picture of the country, so that while we realize the modernization of the country, the Greater Bay Area can also undertake important responsibilities. Last October, when President Xi Jinping visited Guangdong province, he said that we must grow Guangdong province into an important pillar of the national growth, as well as a driving force for the China's modernization. So this definitely has provided new opportunities to the region and injecting new driving force. Definitely, our cooperation between the regions will be based on the current progress and achievements, and give full play to our advantages, so that we can keep opening our horizons to low horizon economy, the marine economy, as well as the digital economy, so that we can realize high quality growth and turning the Greater Bay Area into a world-class Bay Area and turn it into the best Bay Area in the world. Secondly, we must anchor ourselves to the objectives of legal reform, so that we can really tackle the difficult issues. So just like the 2 wheels of a vehicle or the 2 wings of a bird. So we have the one country, 2 system arrangement, and we have our unique legal frameworks. So there's no reference for us to take, and there's no experience for us to borrow from. So we have to understand the relationships between reform and the legal system. We must take all the means to tackle all the difficulties. Last month, Guangdong provincial government issued our legislation plan for 2024 to 2027. In the next 4 years, we will also continue to focus on the areas such as the employment for the youth in the Great Bay Area, the medical instruments and the drugs importation, as well as the track traffic cooperation between the cities. Meanwhile, we will also focus on the environmental protection, as well as the teenagers exchange programs, so that we can work even more on the legislation cooperation. We have noticed that the Hong Kong CE made a speech on his policy address, and he said that be it for the reform or for the legislation, he talked a lot about his plans. So as the next step, we will continue to capture the important opportunities brought by the Greater Bay Area. So we will continue on playing a full role of our unique advantages so that we can keep imperfecting our legal systems and take a pragmatic attitude while seeking for a win-win situation for all the cities. We share the same root, we share the same history. We have a great room to continue our cooperation between different regions. We have joint law firms in the Greater Bay Area. We have the professionals from Hong Kong and Macau practicing in the Mainland. We have joint trainings to the professionals as well. So this has fully shown that as you can see that in July this year, the Department of Justice set up the legal service conferences, and the headquarters of this service mechanism is located in Guangdong Province. So this helps to improve its credibility of our cooperative mechanism and providing a great support to our cooperation in the region. It is not about the non-cities in the Great Bay Area. We have other provinces who are really actually looking at us in our cooperation. For example, the Guangxi Autonomous Region, the Department of Justice is also here. We have representatives from our Guangxi region. Last year, we have representatives from Anhui and Hainan provinces from the Departments of Justice. They also came to attend the Legal Week event in Hong Kong. So therefore, we will continue working hard. And in terms of legal cooperation, we will continue exchanges on the service area, and this is very important. So looking for more opportunities, and we will try to identify areas and approve some more programs so that we can integrate ourselves with each other better. So we will take serious measures to further expand our cooperative areas and deepen our cooperation so that in the three regions we can have more cooperations and keep innovating so that we can build GBA into a systematically open area. As called for by the State Council, we must bench ourselves to the international standards, and from a policy-oriented opening up to the systematic opening up, I think Great Bay Area can take the lead. So basically, those are the points I want to share with you. And finally, I wish a great success to the Legal Week, and I wish you great health and a great stay in Hong Kong. Thank you very much. Thank you very much, Mr. Chen, for your wonderful speech. Please get back to your seat. And welcome to Hong Kong once again, Mr. Chen, and give us an important address as well as the coming exchanges with us for a new chapter. So next, I would like to invite Ms. Liang Wen-ying Coco, Director of the Legal Affairs Bureau of the Government of Macau SAR, to give us a speech. So, Honorable Paul Lam, Honorable Mr. Chen, dear distinguished guests, ladies and gentlemen, thank you very much. Good morning, and thank you very much for coming to the Legal Week. Today we have the theme of joint contribution to the construction of a rule of law in GBA, and here we are gathering with each other to discuss about the new challenges and the new opportunities in legal exchanges in the Greater Bay Area. I think that this is a very important event.
GBA is a front line of nations opening up strategy, and we mentioned GBA's cooperation needs to be deepened and need to focus on the interface of regulatory framework. With the GBA development pushing forward, the exchanges within three regions are more frequent, and we achieve deliverables for the framework construction. It plays a very active role. Macau, as an important member of GBA, we strengthen our legal protection to service a GBA legal cycle. Macau, together with Hong Kong's DOJ and Guangdong's Department of Justice, we established a very important platform to exchange and cooperate on cultivating legal talents. We'd like to build a better GBA. On lawyer cultivation, we have our lawyer test in GBA, and quite a number of Macau lawyers have got the license in GBA. They know Hong Kong, Macau, and as well as the Portuguese-speaking countries. They can facilitate Portuguese-speaking people to invest in mainland China and Hong Kong. For arbitration, in October this year, we finished our accreditation application. So going forward, we will have a full list of arbitrators to be published later this year. We also launch courses to enhance Macau lawyer or arbitrators' understanding of the arbitration in GBA. We encourage them to enter arbitration in GBA, apply what they have learned in that. We will submit it to the joint conference for review. Thirdly is our unique advantage. Macau is positioned to be a tourism center. China and Portuguese-speaking countries will be connected by Macau. Macau's government also actively set forth the 5-year plan. We already have the pathway with the outlined development plan of Hong Kong, Macau, Guangdong development. Our country gave us a clear direction. Macau will play its function to facilitate the economy, culture, and legal exchange between China and Portuguese-speaking countries. This year marks 25th return to motherland. Under one country, two system, Macau is very vibrant and achieved remarkable results in law. We have good environmental for business. We have also been a great power engine for the regional growth. We will keep pushing forward the better business environment, have better legal service, and deepen the cooperation with mainland China and Hong Kong legal entities. We will contribute our legal support to the regional development. Today, we have a lot of legal practitioners, and I believe for GBA, you have your deep understanding, and we hope we can exchange openly, freely, and contribute our wisdom to GBA development, and wish today's events a great success. Thank you, Ms. Lin. Please stay on stage for a group photo. Now, shall we invite Mr. Paul Lam and Mr. Chen to the stage? And let's invite Mr. Zhang, SBSJP, Deputy Secretary for Justice. Welcome to the stage for a group photo. Thank you, our speakers, for your opening remarks. Thank you once again. So, for the new challenges, opportunities of the rule of law in GBA, we will have deeper discussion later on. Please look at the cameraman in the middle. Let's take another photo. Once again, thank you, our speakers, Mr. Chen, Ms. Leung. Thank you for coming. Thank you, Mr. Chen, Ms. Leung, Mr. Paul Lam, Mr. Zheng. Please be seated. Now, the first session, we are very happy to have Judge Jiao Xiaoding, Deputy Chief Judge of the 4th Civil Division of the High People's Court of Guangdong Province. He's going to share practical experience sharing on the judicial implementation of proof of foreign law. Let's welcome Judge Jiao. Mr. Chen, Ms. Leung, friends from law, dear friends, good morning. I'm very happy to be here. I'm very happy to share my view on the construction of rule of law in the GBA. It's a very important topic in terms of cross-border cases to protect the parties, facilitate international trade and commerce. This plays a very important role. Today, I'd like to share for cross-border cases, how do we do the judicial implementation of proof of foreign law? In 1987, the High Court, in terms of economy, jurisdiction cases, we published our judicial interpretation and keep implementing and perfecting the proof of foreign law. And we later on published the first conflict law. Under this law, Clause 10, we made a definition regarding proof of foreign law. And later we published our interpretation in terms of the proceedings, proof of evidence of foreign law and also Hong Kong law. We have detailed interpretation. Last December, the High Court issued the second version of the law interpretation. For proof of foreign law, we have a more systematic interpretation and have better, clearer ways, proceedings that provide the foundation. And this July, the High Court published the first batch of cases that can be used as proof of foreign law. So I'd like to briefly introduce in mainland China courts what are our practices. First is about the definition. It's been quite debatable because in common law countries and regions, they think foreign law is a fact. Claims is that the one who submits the case should have the burden of proof of evidence. But in mainland China, it's different. The judge and the court should take the responsibility. And in the civil law in mainland China, we always say we take facts as the very important matter. So matter it's facts or law, we need to verify them both. And in mainland China, the foreign law has dual roles. It is a law and it is fact. Because of this dual properties, when it comes to proof of foreign law, we pursue the importance on court supported by the client. And based on this guidance, under most of the time, the court can do the investigation only if when the client chooses proof of foreign law, they have the burden of proof of evidence. And how do we define the responsibilities? That means we need to try our very best to investigate. So with the judge being the major body, if there's any loop or if there's any inaccuracy, incompleteness in terms of investigation report on proof of foreign law, we cannot say it's not working, especially when it comes to Hong Kong and Macau law. We can not conclude that proof of foreign law is not accepted. For multiple enterprises, we clarify we cannot, because of different legal advices, can we exclude Hong Kong law from the court. And recently, there's a contract case. The client submitted case-based law and a lot of literacy. They have different interpretation on foreign law, but we didn't exclude foreign law from our court. Through comparison, we made the definition clear in terms of proof of foreign law. And we also explained that clients need to prove evidence and consular general, judicial bodies need to participate in the investigation. The experts from the High Court Commercial Division and overseas experts or other appropriate bodies need to join in the proof of foreign law. And in the judicial implementary in mainland China, the client needs to provide proof of foreign law. In the court, as a judge, as the investigation body, we can ask the client to provide the proof, but it doesn't mean the investigation responsibility goes from the court to the client. The court should provide proof of foreign laws by other ways. And in Guangdong, we started quite early, so we have different cases. In terms of cross-border civil cases, we account 1/3 in mainland China. When it comes to Hong Kong, Macau cases, Guangdong took care of 2/3 of the cases in mainland China. For the cases that use foreign laws, every year we have 100 to 150. Recent years, Guangdong province keep pushing proof of foreign law in Guangdong. We have formed our own character and our own way. First is GBA proof of law, foreign law platform encompassing 30,000 laws and have a lot of law literacy and have 8 law resources, providing public with one-stop, low-cost search place. And this platform has gathered 250,000 visits last year. And we have launched Belt and Road Law System platform. We have thousands of legal experts to provide the proof of foreign law online. We also have guidelines and directive documents. We launched in those guidelines, we say what are the responsibilities and standards of legal professionals. We clarified the fees, and we launched Chinese and English bilingual Q&A, providing clients a lot of proceeding directions. And we have Guangdong's expert pool hired 30 experts from Macau and Hong Kong as the first batch of experts.
So in this way, we can provide support and recommendations to all the judges. Foshan Shunda courts in entrusted Professor Leung of Hong Kong to help with the identification of extraterritorial laws, so that we could shorten the case proceeding process. In this way, we can set up positive connections between us. So the identification of extraterritorial laws is a very important point, yet there are a lot of difficulties in this regard. We had to understand what are the laws and regulations and what are the differences between the extraterritorial laws versus Chinese laws. So, however, they are interlinked with each other. For the course in Guangdong, we take the GBA as a start point and carried out the identification of extraterritorial laws. Meanwhile, we also tried to set up positive connections between us. First of all, we set up the rules and guidance of identification of extraterritorial laws. So we issued a guideline on legal connections between Hong Kong, Macau, and Guangdong. Meanwhile, we also issued regulations on the servicing of their legal documents. So upon the request of the parties, we can also cross-examine the witnesses. And nowadays, some courts have already adopted this methodology, and we're preparing on the guideline 3 on the rules. So focusing on the examination and resolution of the lenders, the disputes between lenders and the borrowers. As meanwhile, we could work out the guidelines on how to resolve the disputes on the money-related or lending or borrowing-related cases. And then number 3, we also focus on the legal cases that happen most often and try to help with the interpretation of the laws. And for the same case, we could apply the Hong Kong laws or the Mainland laws in order to examine their cases, so that we can understand what the differences between different systems and understand the differences on the details. Meanwhile, we also issued 7 batches, 110 important policies in Mandarin Chinese, traditional Chinese, as well as Portuguese, on the marital issues, as well as other regions, and as well as other issues. So through the demonstration for some key cases, we can also help the professionals to get a better understanding of the laws and regulations. The third focus we have is on the building of a synergy between the cities. We have the judges plus the mediators plus jurors, so that we can help the professionals in improve their capabilities of their case resolving capability. We have also prepared a register of such professionals in the IP Court and the Shanghai Court in Guangdong Province. We try to adopt mediation into the legal procedure, so that we can provide legal advice to all the case resolution process. We also set up a platform to share the resources on the extraterritorial laws. And the Department of Justice of Guangdong, working together with the DOJ and the Department of Justice in Macau, we signed the MOU and set up a platform, so that we can set up a cooperative and communication platform, so that we can keep improving our database. And number 3, we also held a lot of seminars and workshops together with the legal parties in Hong Kong and Macau, and the judges and the lawyers in the 3 regions have had discussions and simulations of the court hearings and proceedings, and so that we could understand better the differences between our legal systems. And number 4, keep improving our capabilities of extraterritorial laws. We have selected some judges to attend the Judges Academy for the courses on the identification of extraterritorial laws. Meanwhile, we also worked together with the foreign parties and conducted training to the professionals by focusing on some of the commonly some common areas on the extraterritorial laws. Meanwhile, we also deepened our cooperation with the counterparties. We set up the Great Bay Area case study base, and the Sun Yat-sen University as well as Macau University have worked together to set up a training center so that the judges from mainland can come to Hong Kong or go to Macau for the master's degree or the doctor's degree. Meanwhile, we also deepened our cooperation and exchanges with the foreign parties in other countries, for example, in Portugal, so that we can have more collaborations with the Portuguese-speaking countries and in-depth our communications and exchanges with the judges and the courts in Portugal. Nowadays, we are witnessing a lot of changes in the macro picture, and we are standing at the critical point to rejuvenate our economy, and we are committed to working together with the parties in Hong Kong and Macau so that we can keep improving our capability on the foreign party-related affairs resolution, and so that we can provide better services to the region and help with the high-quality opening up and high-quality economic growth. Thank you very much. Thank you very much, Madam Zhao, for your speech. Please get to stand at the center of the stage, and let me invite Madam Ouyang, the moderator for next session, to come to the stage. Madam Ouyang, please. I would like to invite the speakers to the stage as well for a photo group. And first of all, Mr. Stephen Huang, which is one of the speakers for next session, and Mr. Cheng. So Mr. Neville Cheng, please come to the stage for a group photo. To take a memorable moment of, let's take a group photo together, with all the speakers and moderator on the stage. So once again, thank you very much, Madam Zhao, for your wonderful speech. Thank you. So please get back to your seat, Madam Zhao. And Madam Ouyang, Mr. Huang, and Mr. Zhang, please be seated. So before I leave the stage, we're going to have next session a thematic dialogue, proof of Hong Kong law in mainland courts. So our speakers will discuss and share with you their thoughts on the current situation of the courts in Hong Kong, and share with us the proof of Hong Kong law in mainland courts. We have audience on-site and online. If you have any questions for the speakers, please feel free to scan the QR code on the screen and submit your questions. So thank you for scanning the QR code. So we will have a Q&A session. Our speakers will be glad to take your questions. So Madam Ouyang is the moderator of this session, and she's the Principal Government Counsel, Legal Enhancement and Development Office, Department of Justice. So in addition to Madam Ouyang, we have two speakers. So first of all, Mr. Neville Cheng, the partner, CAN Lawyers. And we have Mr. Stephen Wang, a senior partner, Beijing Duckwitt Law Firm, Shenzhen office. Without any further ado, let me hand the podium to Madam Ouyang. Thank you. Thank you very much. Good morning, everyone. I'm very happy to be here and have a discussion with our speakers at this the annual event organized by DOJ at the Hong Kong Legal Week. So the theme of the discussion for this session is the proof of Hong Kong law in mainland courts. So before we start, let me share with you very briefly how important this topic is and what is the background. As you know, that the country is promoting opening up to the world, as well as the implementation of a Belt and Road Initiative. We are also carrying out legal reform in the Greater Bay Area, be it professionals like judges or lawyers. We are dealing with more and more cases and civil cases. So we are very happy to see that under the revision of the CEPA, Hong Kong and Mainland have agreed that we will expand our current 2 cities into more cities to have more measures on the opening up, so that the application scope of Hong Kong laws will also be expanded. As Honorable Mr. Lam said, that so for the Hong Kong businesses will be governed by Hong Kong laws, and this measure will be further expanded to cover a wider region. Currently, it is on the free trade zone only, and now in the future, this practice will be expanded to cover 9 cities in the Greater Bay Area. So, under this context, we found it even more necessary for us to understand what is the Hong Kong law and what is an extraterritorial law, so that we can improve our performance in dealing with cases and protect the interests of the parties, so that we can keep improving our business environment. As Madam Jiao said in her speech, the legal systems are very complicated ones, be it in Mainland, in Hong Kong, or in other countries, and we have encountered a lot of difficulties and challenges when dealing with the foreign party-related cases. And today we have the honor to have 2 very experienced speakers to share with us their thoughts. One is Mr. Cheng, and the other is Mr. Wang. So they will share with you their experience and their thoughts. Just a reminder, if you have any question to the speakers, please scan the QR code on the screen and input your questions on the platform. So, first of all, Mr. Zheng, you can please share with us how you deal with the cases in Mainland and working together with the peers in Mainland courts. Thank you. Thank you very much. So, good morning, everyone. Talking about the identification of extraterritorial laws in Mainland, we have to understand what are the requirements on this regard. So, under the big background of the rule of law in China, we have to understand what significance the extraterritorial laws and the advocacy of such laws have on the outgoing businesses. Because being a business, you care about the opportunities. So for the People's Court in Mainland, when they deal with their case, if there's any extraterritorial law is involved, they have to identify what it is, as Madam Jiang said. So regarding the application of in addition to the explanations issued by the government, so we now have a set of rules on identification of extraterritorial laws. Now I want to talk about the responsible entity first of all. So for a lawyer, perhaps this is a very special topic. For example, you received instruction and you are going to identify the extraterritorial law, and now you have a party, and the party comes to you. For example, it is a litigation. So by your responsibility, you have to take care of his interest. However, this situation is a bit different.
The proof of foreign law is to assist the People's Court in Mainland China. We need to remember that. Otherwise, our legal advice won't be neutral. Otherwise, it will impact our legal advice, legal opinion. In the guideline, we need to protect the rights of the client to voice their opinion. They say when we search cases and clause in the PC, we know that case, and when we are writing the legal opinion, we need to say the sources, the clause, to better refer to the content source and case details for easier communication and reference. When it comes to efficiency and accuracy, there's a case saying in the court when they're having a pre-court meeting, they need to have a better way to do the proof of foreign law. It's like CMC, Court Case Management Conference. And we see in mainland China, they are also making the advancement. And the judicial implementation is more like judicial practice in Hong Kong. We need to understand what we're doing. And when it comes to extraterritorial proof of foreign law, we need to focus on the following. First, the very difference between common law and civil law. When we are providing legal opinion, we need to explain the common law principle, history, because no matter it's the tradition, ways of thinking, we have large differences between common law and civil law. Even some legal practitioners in mainland China, they have certain understanding of common law. But when we are having the proof of foreign law, we cannot make sure the judge knows Hong Kong laws. So we need to clearly state common law, history, tradition. Why history? Because Hong Kong is special. It was a British colony, later on returned to China. And during the British colony, there was a very professional authority in Britain where Hong Kong needs to listen to that. And now we returned to the motherland. There's some misunderstandings after return. Actually, the previous cases before our return, we still need to take them into consideration. So we need to say history just in case if there's any misunderstanding. And for common law, Hong Kong's courts will refer to other cases in other jurisdictions. It's different from mainland's civil law. So we need to make explanations. And Hong Kong has basic law. You also need to explain the relationship between basic law and common law. And you cannot compare constitution with basic law. Basic law is under constitution, so it's very special. In the legal realm, we need to explain that. And when we talk about extraterritorial legal opinion, just now Judge Jiao mentioned Hong Kong, after writing the legal opinion, we can go to the court. However, a lot of times, according to mainland courts tradition, you are not allowed to go to the court. You need to understand the legal opinion that we written may not give us another opportunity to explain. So in written format, we need to include everything, and we need to think what we are written. Will it arise any problem? Will it lead to any other potential topics? So you need to be detailed as possible. So when we are writing, we need to keep in mind of that. And we care, as I mentioned, write as broad, as wide as possible. We need to think about potential questions and to that thing really need to pay attention. The differences and common grounds between two laws. It's inevitable that people have different experience. That's very common. However, when it comes to cross-border cases, sometimes we use our local jurisdictions thinking to judge other places' courts or cases. For example, in company law, Hong Kong doesn't have the legal representative. However, in mainland China, China do have legal representative. However, in Hong Kong, all the operations are decided by directors. We also have some power of attorneys, but it's different from the legal representative in mainland China. They're of different levels, so we need to make detailed explanation. In Hong Kong, power attorney is director in Hong Kong company. You can replace them. So these are two different things you need to explain. And also, we have one-man company. When you have one-man company in mainland China, if there's any dispute, you need to bear all the liabilities in mainland China. It's very clear that management, personnel, and debts are all different. But in China, it doesn't matter, and you need to explain. And in our written rule, we have different cases, case law. I think case law is very difficult. You need to explain as careful as possible. But it's inevitable. We are assisting people's court, so we have to explain as detailed as possible. And also company chops or stamps. In China, stamps are more important than signature. In Hong Kong, it's different. In Hong Kong, you don't need to use steel stamps. So it's possible, like the chops are missing in Hong Kong companies. Chops or stamps in legal cases, they don't have any position. So there are a lot of differences and common grounds. When it comes to writing, you cannot just answer to one question. You need to think, for the similar cases, what are the China law situation, and explain further. Thank you. Thank you. In such a short time, we had a lesson from you, Mr. Chen. How can we better prepare or assist the courts in China in proof of foreign law? And thank you very much for telling us the features and the company law, applicable law, including legal representatives, board of directors. I believe you benefit a lot from it. And now, let's hand over to Mr. Huang. He has a lot of experience in working with Hong Kong lawyers. And in Hong Kong courts, you also do proof of China laws. So without further ado, Mr. Huang, please. Good morning. Peggy asked me first, proof of law in Hong Kong, second, proof of law in mainland in Hong Kong. And just now, Mr. Chen mentioned a lot because Mr. Chen is telling as an investigator, as a prover, as a mainland lawyer. Actually, I am a Hong Konger, but I work mainly in mainland China. Mr. Chen mentioned as a prover, how can we assist the client's court to assist them? And now, as a mainland lawyer, how can we assist Hong Kong court? Or from a an opposite view, what are the problems we always encounter? First, proof. Prove what problem? As mainland lawyer in a case, we need to prove Hong Kong law, accurately know what are the Hong Kong issues and problems, and we ask the experts. And some bad cases, examples. For example, in a case when we are trying to prove the law to verify if the contract is effective, the Hong Kong lawyer almost wrote an encyclopedia for us, everything and then give us a conclusion. So I think, how can we focus homing in on different cases? It's very important. It's not only mainland court checking Hong Kong law, vice versa. When I was serving as the expert witness, because in Hong Kong it's very special, at the case manager process, we have a very strict proceedings, and they need to put forward the questions they would like to verify. For good Hong Kong lawyers, they will coordinate with us on the question that we are going to ask. A lot of times when I step in, they already have the question set for us, and I have found the problem. We shouldn't ask that way, and then we revise, so it actually prolonged the process. That's a matter that we mentioned, and Ms. Zhao mentioned in mainland China, the proof of foreign law or Hong Kong law is a matter of law. If we verified it wrong, it's a very serious mistake. And in Hong Kong, it's just submitting the facts. I think witness is important. My advice is, when you are serving as a Hong Kong witness expert, when you are signing the contract or document, there will be a reminder. Even if the client pays you, you need to serve your responsibility to the court as a witness. That's very important. And when you see Hong Kong case law, some expert witness or extraterritorial law experts, they took themselves as the advocate. That will be criticized by the judge. So we must be really careful. And as witness, you have your own role. Facing the Hong Kong court, you need to uphold integrity. And once you position yourself as an advocate, when you are arguing, it will be easy for you to be not neutral. So in Hong Kong court, it will affect your authority for your legal opinion or advice. So for a witness in Hong Kong court, your content is not most important. Your position, whether you have integrity or not, is most important in Hong Kong. I have 1 minute left. So Judge Jiao and Mr. Zheng mentioned different ways of proof of foreign law. In Hong Kong and mainland China, they both have different kinds of ways, methodologies. The most important point to summarize is people, is us, is legal services provider. Having immunity is not enough. We need to have enough kung fu. And with the GBA development, we always say we hope to build multi-law talent pipeline. We hope one lawyer can be familiar with several law systems, no matter from legal or law service provider, for jurisdiction, or for judiciary parties. It can improve our service quality. When looking at the 3 regions, especially in Hong Kong, we are promoting international law talent training academy. I think it can help us, equip us with ammunitions. That's very helpful. Thank you.
Thank you very much, Mr. Huang, for your sharing. And actually, he pointed out smartly how to ask the right question to the right person. So you must focus on the right question so that you can understand how to find out the extraterritorial laws. And also, he said that we have to build up our own capabilities. I believe that this is the right topic for us to discuss about because we have already got a group of GBA lawyers from Hong Kong, from Macau, and from Mainland, so that they can practice in the region. They will definitely contribute more to the finding out of extraterritorial laws as well as the cooperation because they know the Hong Kong laws, they know the Macau laws, and they also know the Mainland laws. Of course, under this context, we must work with each other better because when we can achieve better results through this and may I ask the question to them. So just now, Mr. Zheng said that when you try to find out the extraterritorial laws, there are a lot of improve and advice on this regard. Actually, we are just like a bridge because we are a super connector in finding out the Mainland. So if we want to find out the extraterritorial laws, you have to understand the Mainland laws and the Macau laws. We must learn from the peers in Mainland. So you are encouraged, everyone is encouraged to get to take the examination and get your certificate for practicing in the Mainland. So just a little bit marketing. You know, I'm from Hong Kong. So why there is a GBA certification exam, why not in Hong Kong? Actually, we have the OSCE. This is for the overseas the lawyers practicing certificate. So you have 5 years for the overseas practice experience. You can take this exam. And actually, it came into existence earlier than the GBA examination. So this is a two-way mechanism. So you can practice here, you can practice in GBA. So our bridge is even better and bigger. Thank you, Mr. Zheng. Thank you for your encouragement. Our peers in Mainland can also take the examination in Hong Kong for the certificate. And all the lawyers in GBA are also encouraged to play an even bigger role. And this is a very important bridge. I have received some questions from the audience. So some people asked, when in terms of finding out their laws, different practices in Hong Kong and Macau, as we know. So a question for Mr. Wang. How can we make better use of the differences between our legal systems and turn into a favorable tool for us? It's that take advantage of the difference and turn it into an advantage. Very good point. So our focus question, as Madam Zhao said, that we have different natures when we try to identify the extraterritorial laws, different practices, different mechanisms in Mainland and in Hong Kong. In Hong Kong, we have a very high expectation on the accuracy of such identification. If your process is not correct, and then the result will be converted. And so sometimes we have official evaluation, as Madam Zhao said, in Guangdong Court, the People's Court, the High Court. There is a guidance on this. I said that this is the pre-context examination or identification of extraterritorial laws. So this is an official document. So there is some semi-official government. For example, the property court, they have regulations or policies as well. So mainland part, we have done a lot. But in Hong Kong, you have experts, witness, you have witness. Even though you're talking about nonsense, as long as the judge doesn't care, it's all right. So I have always been thinking about, proposing that. So we have already got some cases, verdicted cases on this, and there are a lot of statements or the descriptions of the mainland laws. In Hong Kong, it is not an official document yet. However, you can take it as a reference. So actually, I can put it this way: the verdict cases. All the mainland laws in the verdict cases in Hong Kong, I can put this name on it. So whether this identification is correct or not, and gradually people get this awareness. It's not a matter of a system matter. It is just like a habit or the cultural thing in this sector. Thank you very much, Mr. Wang. A very good advice and also homework for us to do. So definitely I will at least give it some thoughts. I think we are running out of time. Just now, two speakers shared with us their thoughts, and before that, Madam Zhao talked about the identification of extraterritorial laws in mainland courts. They also got some policies and rules, and they encourage the professionals, including the judges and the lawyers, to exchange more so that we can understand better on each other's legal systems. So we have had a very good conversation just now. Mr. Zheng, and Mr. Wang both gave us a very valuable thoughts on the identification of extraterritorial laws. So I hope that you can continue supporting us and so that we can play a better role in this regard. I think my time is up. So please, a round of applause to our two speakers, as well as Madam Zhao, for the kind sharing. Thank you very much. Thank you. Thank you, Madam Ouyang, for your moderation as well. Thank you. And thank you, Mr. Huang and Mr. Zheng, for your in-depth sharing on this topic. Thank you. Please get back to your seats. Ladies and gentlemen, a round of applause to our three speakers. Once again, thank you very much. Now we're taking a 10-minute break. So we have prepared coffee and the refreshments outside. Please remember to take your own belongings when you leave. For those online, you don't have to log out because we're going to resume next session in 10 minutes. Ladies and gentlemen, please come back in 10 minutes.
些时间只有10分钟。
So only a 10-minute break.
我们10分钟后见，谢谢。 来宾、女士们、先生们，我们下一个环节现在立马就开始，请大家移步回到我们会场里面就坐，谢谢。Ladies, gentlemen, our next session will now commence, so please kindly make your way back into the auditorium and be seated. Thank you. 咁多位嘉賓，我哋接住落嚟下一個單元嘅環節啦，立即開始啦。所以喺呢個時候啦，麻煩大家移步翻去到會場。
The next session is about to begin. Please come back and be seated. Thank you. Don't miss out the exciting session.
Dear guests, ladies and gentlemen, welcome to the GBA session. And now we are having the next legal services and judicial relations, contributing to the construction of the rule of law in the Greater Bay Area and providing greater convenience and stronger legal protection. May we invite Mr. Simon Kwong, Registrar of the High Court, the Judiciary of the Hong Kong SR government, to deliver his speech on the operation of the arrangements on mutual legal assistance in civil and commercial matters between Hong Kong and the Mainland China. Now, Simon will discuss the mutual legal assistance in civil and commercial matters between Hong Kong and the Mainland China. He will also share the operation of the arrangements. So, over to Mr. Kwong, please.
Chan, Director Leung, fellow legal practitioners from Greater Bay Areas, Hong Kong, Macau. Distinguished guests, ladies and gentlemen, good morning. Welcome to Hong Kong to attend this event organized by the Department of Justice. It is my great pleasure to address you today at this Hong Kong Legal Week 2024. In this era of increasing cross-border interactions, the legal frameworks that govern mutual legal assistance, which usually we shorten as MLA, between the Hong Kong SAR and the mainland, are vital to uphold justice and facilitating fair dispute resolution. In this context, Hong Kong SAR has played and will be playing a pivotal role. Today, I will discuss the operations of various arrangements on MLA in civil and commercial matters between the Hong Kong SAR and the mainland from a judicial perspective. I will provide an overview of the 9 arrangements that have been signed between the Hong Kong SAR and the mainland, highlighting the practical challenges we have encountered and the progress we have made. I will then focus on 2 specific areas that I am frequently engaged during my work, the reciprocal recognitions and enforcement of judgment in civil and commercial matters. Again, in short form, we call it RUJ. And the service of judicial documents in civil and commercial proceedings. Then I will briefly outline other MLA arrangements and provide relevant statistics. As I said, there are up to now 9 arrangements since 1997 up to now, signed between the SAR and the mainland. The first in line was entered into force in 1999 for service of judicial documents and civil and commercial proceedings. In broad terms, there are 4 broad areas whereby the arrangements may cover, such as the service of judicial documents, taking evidence. These are procedures. And then we have another big areas covering arbitral awards, mutual enforcement of arbitral awards. The first arrangement was entered into force in 2000, and then we have supplemental arrangement entered into force in 2020 and 2021. And then we have the interim measures in 2019. And the next broad area is what I have said, REJ, the recognitions, mutual recognitions of judgment in civil and commercial matter. The first arrangements of reciprocal enforcements was entered into force back in 2008. That would only cover those who had choice of court agreements. And of course, more recently, in January this year, we have a more broad arrangements covering other civil and commercial matters, which was entered into force in January this year. And of course, prior to that, we have reciprocal and recognition and enforcement of civil judgment in matrimonial and family cases. That was entered into force in 2022. And there is also an arrangement which cover assistance to bankruptcy and insolvency proceedings. I think that we need to differentiate. In mainland, they do not have so-called insolvency proceedings. They call it bankruptcy proceedings. In Hong Kong, we call it insolvency. In fact, we only have arrangements for recognizing insolvency proceedings, either in Hong Kong or in mainland. with all these contexts established, I would like to turn to the first key area that I would like to discuss this morning, the reciprocal recognition and enforcement of judgment in civil and commercial matter, the REJ. The first arrangement that we have made is back in 2008, more than 16 years ago. This REJ is a cornerstone of fostering legal certainties and promoting cross-border commercial activities between the Hong Kong SAR and the Mainland. This framework has evolved significantly over time. As I said, marked by two key arrangements. The initial step towards REJ was taken back in 2008 with the signing of the arrangement on the reciprocal recognition and enforcement of judgment and in civil and commercial matters pursuant to the choice of court agreements between parties concerned. This arrangement led to the enactment of the Mainland Judgment Reciprocal Enforcement Ordinance, Chapter 597 in Hong Kong SAR, establishing the first formal mechanism for recognizing and enforcing some specified judgment between Hong Kong SAR and the Mainland. Under this arrangement and the local law, as I mentioned, Cap 597, there is one paramount prerequisite. That is, we must satisfy that there is a parties agreement which was concluded in relation to a specified contract and specify Mainland or Hong Kong court as having exclusive jurisdiction over dispute arising from that contract. And all more important, it must exclude jurisdiction of other courts. So it applied to quite specified areas. For the last 16 years, we gathered some experience on these applications for either registering judgments in the Mainland court in Hong Kong or applying for certificate of the registrar to have the Hong Kong judgment to be enforced in the Mainland court. We have on occasions refused applications. So it's not an exercise of rubber stamp, not just because the applicants to apply for registrations of a Mainland judgment, we must approve or grant registrations. There are two main areas whereby I wish to touch upon with the limited time that is available today. One is that quite frequently we find applications without referring to a specified agreement which provides for an exclusive jurisdiction clause. Or else, on face of the agreement, it contains a non-exclusive jurisdiction clause. Furthermore, this is quite recent developments whereby I myself find in some of the applications, the agreement contains what usually we call a symmetric jurisdiction clause. What is a symmetric jurisdiction clause? This is quite frequent for international finance agreements, whereby it may allow the creditor to sue not just in one court, but in the exclusive jurisdiction clause, whereby the debtor agree to submit. But on top of that, it provides that that exclusive jurisdiction clause is only for the benefit of the lender. The lender can choose to sue in other jurisdictions whereby the debt-toll asset may situate. So that is the reason why we call it asymmetric jurisdiction clause. In fact, in one of my previous case, I refused applications upon hearing submissions. That case went up to appeals, and it was eventually reported in the case of Industrial and Commercial Bank of China Asia Limited and Wisdom Top International Limited. In that case, Madam Justice Aoyang ruled that on appeal from me that asymmetric jurisdiction clause do not satisfy the choice of court agreement requirement under Section 3.1 of Cap 597 due to the lack of jurisdictional certainties, which contradict the spirit of the REJ arrangement. In fact, in that case, the court has also referred to a similar arrangement under Hague Conventions. In fact, there was expert from the Hague which conclude that a symmetric jurisdiction clause was not an exclusive jurisdiction clause. So I think that is an important aspect for those who advise an international finance company or bank that if they wish to take advantage of having the judgment obtained in Hong Kong to be recognized in Mainland, they better not to use a symmetric jurisdiction clause because we have binding authorities that this is not an exclusive jurisdiction clause that can enjoy the rights under the Cap 957 to have that judgment to obtain such certificate from the registrar and to have the judgment recognized and enforced in the Mainland. Perhaps there's another areas whereby I find troubles when parties come into enforcing either a Hong Kong judgment or a Mainland judgment, especially in guarantee. For those commercial lawyers, you may experience that in some bank guarantee, in some other commercial guarantee, only the guarantor signed the agreements, not the lender. This will present the problem. Even if the guarantees contain a exclusive jurisdiction clause, that is only the agreement of the guarantor to submit to that exclusive jurisdictions of Hong Kong court or the Mainland court. The lender has not agreed to submit to that exclusive jurisdiction clause. This is a requirement of Cap 597 that there must be an agreement by both parties, and the agreement should be in writing or in some electronic means. So if you are not signing or agreeing to the exclusive clause as the lender under the guarantee, there may be a problem for you eventually to have it enforced either in Hong Kong or in the Mainland. In fact, there is quite a recent case that you can see on the screen. It's the Beijing Renji Real Estate Development Group Company Limited and Su Min. The appeal court judgment was recently handed down last month on the 2nd of October 2024. That judgment upheld the first instance court decisions that despite there are some other agreements which may contain exclusive jurisdiction clause. But for that case, since this is an action against the guarantor, the guarantee did not specify the Mainland court has exclusive jurisdictions. So in that case, the Court of Appeal decided upon constructions of the Cap 597 to hold the first instance decision that the judgment in the mainland court cannot be enforced in Hong Kong. In fact, that case, initially, the registration application was approved. Eventually, the defendant applied to set aside. That is part of the procedures that is available under Cap 597. And the court of first instance agreed to give that particular set aside. It seems I'm running short of my time. So perhaps we go to the statistics. For the existing ordinance, Cap 957, we have received so far 251 applications from the mainland to register the mainland judgment in Hong Kong, while Hong Kong courts received 111 applications for registered certificate for enforcement of Hong Kong judgment in the mainland courts. You can see there are limitations on the Cap 597, that it only applies for cases whereby parties had an exclusive jurisdiction clause. That is the reason why eventually we need to move on. As a result of a discussion between the Hong Kong SAR governments and the Supreme People Court, we enter into a new arrangement in 2024, whereby we enact another ordinance called the Mainland Judgment in Civil and Commercial Matter Reciprocal Enforcement Ordinance, Cap 645. It removed the requirement of exclusive jurisdiction clause. It extends not just to enforce and recognize monetary judgment, it extends to non-monetary judgment, so that such as injunctive relief, specific performance can be enforced. In fact, the case type also extends to intellectual properties also, although there are some excluded judgment in intellectual property cases. And more important is that in the Cap 597, it only applies to judgment of the Court of Final Appeal, High Court and District Court. So far, we did not receive any recognitions of Court of Final Appeal judgment in the mainland. Mostly are coming from High Court. For the new ordinance 645, it will cover all the courts in Hong Kong, excluding magistracy. All the civil and commercial courts in Hong Kong, coming from the top Court of Final Appeal, High Court, District Court. It also covered tribunals, Competition Tribunal, Lands Tribunal, Labor Tribunal, and Small Claims Tribunal. In fact, we have received some stakeholders' comments that they wish to enforce Labor Tribunal's award in mainland, especially for those employers who fled away from Hong Kong to the mainland, so that they wish to enforce the judgment in mainland, so that eventually the Labor Tribunal award now can be enforced and recognized in the mainland courts. For the new ordinance, in fact, both ordinances is now operating concurrently, since the old ordinance 597 will apply to judgment that were entered before January this year, and the new ordinance will apply to judgment entered after January this year. So they are now still operating concurrently. We are still receiving applications from both sides for enforcement under the old law, and we also receive applications for the new law. Since its operation in January, we have so far received 9 applications for registration of mainland judgment. 3 orders has been made for registrations. In fact, for your information, the first application coming from the mainland court, or the applicant from the mainland to enforce a mainland judgment, is an applicant in person. is a litigant in person, is not legally represented. I would explain why they will have the resources to do so, because we have quite an helpful practice direction and rules that would assist them with forms that they can use for the applications. But there are other matters which create problems for these kind of application whereby we can see. So we have 9 applications for registration of the mainland judgment, and so far I have received 12 applications for registered certificate for enforcement of Hong Kong judgment in the mainland. So far, 8 registered certificate was given. For the new ordinance, there are areas whereby we see there may be common problems, such as they failed to state the reasons why they need to enforce the relevant judgment in Hong Kong or the mainland, and provide some evidence to show assets owned by the respondents, the debtor, in the place of enforcement. And in some applications, the applicant had some enforcement proceeding in Hong Kong or in mainland, and they had not state clearly the result. And in some of the cases, there may be some appeals, outstandings. Again, there may be questions why they would not wait for the outcome of the appeals. One of the areas which we find at present there may be some problem is that the certificate from the mainland court may not satisfy the requirement of the Hong Kong law. In fact, we have discussed this with the Supreme People's Court. So hopefully we would have some sample certificate for the mainland court to be adopted so that they can issue some certificate in the sample form, such as our PD, the practice direction. We have a certain kind of certificate which will cover the requirement of the law. Some minor area is quite usually they did not calculate interest up to the date of the applications. Again, this is a requirement so that we will know the exact total amount of the debt. As I said, when we implement the new law, we provide rules, and we also issue Practice Direction 38 with reference samples. I think that would help not just lawyers, but as I said, the first application from the mainland is coming from a litigant person residing in Dongguan, so they have the resources to know how to apply even without the assistance of a lawyer. So I think that could help. So in case if you have interest, you can go to our practice directions to see the contents. I can't spend the time today. In fact, I'm overrunning. There's a problem that I'm overrunning for 8 minutes already. So if you are interested, we had given a seminar in January this year when the new law implemented, and all the resource material, including my presentations in Chinese that time, are now all on the DOJ website. So that you can go to that, you will see all the presentations there, and you will see the details of the new reciprocal enforcement law there. So the shift from CAP 597 to CAP 645 signifies a significant improvement in the REJ landscape. As the awareness of CAP 645 increase and its benefit become more apparent, applications under the new arrangement are expected to rise steadily, while the application under CAP 597 will likely continue but declining. Further monitoring and refinement of process based upon practical experience and feedback from stakeholders will further solidify the effectiveness of this vital legal mechanism. The next area that I wish to talk this morning, I may need to expedite a little bit about, is the service of judicial document in civil and commercial proceedings between the Hong Kong and mainland courts. You will see since it was implemented back in 1999, every year we receive a lot of requests, both from the mainland courts and from parties in Hong Kong, to serve documents in respective places. With more business transactions, cross-border business transactions, we will expect more applications for coming. You will see we have last year received 1,300 odd cases from the mainland court, and we have entrusted about 1,500 documents and cases to the mainland court for service. I'm pleased to report that under arrangement, we need to complete the service within 2 months. For our Hong Kong bailiff, who receive requests from the mainland court for service, our completion rate is 99.61%. One case is outstanding at the time when we calculate the statistics because that case was pending for service. Otherwise, almost all the cases would complete within the 2 months requirement under the arrangement. Usually we see there are a number of reasons for unsuccessful service. It is common for not just Hong Kong court, but the mainland court. Correct address, but no such recipient. Door lock, no one answer. Incorrect address. In one of the extreme cases I heard from my bailiff that received requests from the mainland court, the plaintiff in the mainland proceedings state to serve the defendant at彌敦道. That's all. It creates almost an impossible task for the court bailiff to find someone at Nathan Road without specifying the numbers or building or more details. So I think for those who advise the litigant in the mainland, they have to provide detailed address for us. Otherwise, our bailiff, even with all their, I must say, attempts try to make, they cannot serve someone living at Lei Dun Dao. Nathan Road is a long road in Hong Kong. So we cannot try to attempt someone. In fact, this is different from the mainland court. For the mainland court, they would investigate to find the defendant to serve them. In Hong Kong court, we are not able for the bailiff to investigate. We don't have that resources, and we do not have the power to investigate someone. We cannot access to the computers of the police. We cannot access the computers of other enforcement authorities so as to find someone living in Hong Kong and where they lived. So this is the problem why we do not have a high success rate for service. But I think with the assistance of the litigants, if they can provide more detailed address, we would achieve a better success rate. There are some analysis as to what kind of cases we need to serve across the borders. The majority is still family divorce cases from Hong Kong. Family courts divorce case dominate the majority's writs or petitions that need to serve in the mainland. One areas we find there are more requests for service of judicial documents from the mainland court is IP cases. Intellectual property cases, you will see Last year, we suddenly received 152 requests as compared in 2022, 0, or 2021, 2. So there is a significant increase of requests for service of judicial documents relating to IP cases from the Mainland Court. We try to improve the success rate of service of documents and trusts to us by the Mainland Court. Since September 2021, we would serve judicial document on body corporate by leaving at this register office. So in fact, we try to convince the Supreme People Courts that when the courts entrust us for service on body corporate, they would better to enclose or attach a certificate or a certificate of the place of registered office of a company, limited company in Hong Kong. In fact, you can access to that information, as I understand, free of charge from the website of the company registry in Hong Kong. If the company is registered in Hong Kong, you can find the address of their registered office from having an internet search. Even if they charge, if you need to print it out, the charge is rather minimal. But with that certificate, I can tell you, you can achieve 100% success rate for service of judicial documents of a limited company in Hong Kong. Since it is the provisions in the company's ordinance that service on limited company in Hong Kong can be served by leaving at its registered office. We do not need to find an officer. In the past, we need to effect personal service of the writ or the judicial documents on the officer of the companies. Many a time, our bailiff went up to see that this is only a secretarial company. There's no officer of the company there. This is only a service address, so that we cannot serve on any persons who are not officer of the companies. But now, if we have the certificate of the registered office, then we can serve by simply leaving the documents at the registered office. It could definitely enhance the success rate for service of judicial documents from the Mainland Court in Hong Kong. We can see the service arrangement remains an important tool for facilitating legal proceeding between Hong Kong, SAR, and the Mainland. Ongoing efforts have been made to improve the success rate of service of judicial documents by our respective courts. At this stage, through assistance of the Department of Justice, our judiciaries has been actively and constructively engaged in discussion with the Supreme People's Court with a view to reaching a new service arrangement with the Mainland shortly. We hope that that would improve the means of service, the weight of service, whereby we at present encounter. Since, for example, if our Hong Kong legal process cannot be served in the usual mean in Mainland, the matter may be stopped there, since at the present moment we do not have arrangement with the Mainland Court for making public announcement. They have no so-called, what we usually in Hong Kong call substitute service by making advertisement in newspapers. In Mainland, they do not have these. We must serve according to the local law of the Mainland, so that we must, as required under Order 11, Rule 5A, to serve through the judicial authorities in the Mainland. So at the present moment, if the Mainland Court cannot serve the documents, if they are unsuccessful to serve, the matter may stop there. So that we hope, we are discussing with the Supreme People's Court to see if we can have a new service arrangement shortly. By then, definitely the Department of Justice will make appropriate announcement. Maybe I would also stand in this platform again to explain the new arrangement. So I think that what I try to discuss this morning. There are other arrangements whereby I will quickly go through. In fact, you will see my PowerPoint. For the arbitral award, there are not many. For taking evidence, there are even less, both in both courts, so that may not be frequently utilized by parties. Insolvency, that is a growing area recently. Again, this is not my expertise, so I better to reserve any time for my insolvency judge to give a more detailed presentations. But you can see there are more application recently. And in fact, despite the arrangements cover only private areas, that is from Shanghai, Mainland, and Shenzhen, there are letter of request received from non-private areas for giving judicial assistance in Hong Kong from the mainland court. In fact, for cases that have been decided, we grant enforcement under common law, not under the arrangements, so that we interpret the law more broadly than just according to the arrangement, since the arrangement only covered the three private areas, Shanghai, Mainland, and Shanghai. In fact, there are cases whereby it comes from other courts. In Hong Kong, recently we have quite a number of cases from liquidators in Hong Kong to seek assistance from the Hong Kong court to issue letter of request to the Mainland court for recognizing and enforcing winding up proceeding in Hong Kong. In fact, every letter of request that had been sent to the Mainland court are signed by me. So to that extent, I will see how these matters will proceed. Of course, there are also REJ in matrimonial and family cases. Again, we have received 6 from Mainland court and 26 from Hong Kong court to enforce Hong Kong judgment in the Mainland court relating to matrimonial and family cases. I better to go to my conclusion, otherwise I overrun. Usually in my court, I would not condone overrunning, so I better not to do it myself to transfer time for the other part of the talks. Perhaps our independent judiciary strives to uphold the rule of law. The MLA arrangements between the Hong Kong SAR and the Mainland serve as a foundation for efficient resolutions of civil and commercial disputes. The data and practical experience I have shared this morning reflect the importance of these arrangements in ensuring that legal processes are respected and judgments are enforced across borders without the need to commence and duplicate the same set of legal proceedings in the respective courts. While challenges have been encountered, I believe that with the continued refinement of these arrangements and increased familiarities among legal practitioners, cross-boundary legal assistance will become even smoother and more effective in the future. And lastly, allow me to quote what the Chief Judge of High Court had said in the REJ seminar back in January this year. He said in his concluding remark, which I share, as the only common law jurisdictions that enjoys such a comprehensive mutual legal assistance scheme for arbitration and civil and commercial matters with the Mainland under the MLA framework, Hong Kong will continue to strive as an international financial center and dispute litigation hub in the region. This really underscores the unique strengths and advantages we have under the one country and two system principle. Lastly, I wish all the success of the Department of Justice to hold these legal weeks this year. And I hope for all the visitors coming to Hong Kong to attend these seminars will enjoy your stay in Hong Kong, not just attending the seminar, but other activities in Hong Kong. Especially, I see there is a cocktail reception tonight at the former French missions building. In fact, that was also the former Court of Final Appeal building, which I had been working for almost 10 years before it moved to the Jackson Road building. So enjoy your stay in Hong Kong and good health. Thank you very much.
谢谢，谢谢邝先生的。
Thank you very much, Mr. Kwang, for your wonderful sharing. Please come to the center of the stage, and we're going to take a group photo. And I would like to invite the moderator of next session, senior lawyer, Mr. Chu. Please come to the stage as well. I would like to invite our speakers as well. We have Madam Huang. Mr. Karen Huang, Mr. Ho Luk Chen, as well as Mr. Henry Yu. Please also come to the stage. So please stand at the center of the stage and looking at our official photographer. Thank you very much. So once again, thank you very much, Mr. Huang, for your keynote speech. Thank you. Our moderator and speakers for next session, please be seated. So next session, we're going to have a panel discussion with a theme of legal services and judicial relations. So the speakers and the moderator will have an in-depth discussion on contributing to the construction of a rule of law in the Greater Bay Area and providing greater convenience and a stronger legal protection for trade and economic activities and social interactions between Hong Kong and Mainland. Just a reminder to all of you, if you have any questions, please feel free to scan the QR code on the screen to submit your questions. Our speakers will take your questions as many as possible. So we have 3 speakers on the stage, as well as Mr. Kwan as the moderator. So first of all, thank you very much, Mr. Kwok, as the moderator. He's the barrister from Temple Chambers. And the 3 speakers are all experts in the area. We have Mr. Ho Luk Chen, he's a barrister from Devon Chambers. We have Madam Karen Huang, is a founding partner of Shi Wang & Co. Solicitors. And then we have Mr. Henry Yu, he's the partner of Illinois Law Office. Without any further ado, let me hand the podium to the moderator, Mr. Kwok, please.
So the leaders and guests, we are discussing whether we should conduct it in English or the Cantonese. But first of all, let me introduce in the Cantonese, and as time goes on, that you can also conduct it in the Mandarin. I'm really honored to be able to participate in the Legal Week 2024. Today is the 4th day of the conference. The title for today is quite long, so you could see that this is very rich in terms of content. And then as the convener and MC has already introduced our guests, but I would like to go a little bit further. My name is Xu Weiqiang. I practice in Hong Kong, and I mainly practice in the commercial and civil dispute, and then also the cross-border and international arbitration. I have participated in the first accreditation examination now that I work in one of the legal firm in the Greater Bay Area. I know that some of our guests also got that qualification, and then they also serve in the Greater Bay Area. And so I would like them to share the experience. And today I also see some familiar faces. And then they are my seniors. And then I really want to extend my welcome and warm welcome to you all. And today we heard the Judge Kwang and about their civil and commercial proceedings, how they could be recognized and then provide service between the two areas. So you have a better understanding about those arrangements. And based on these arrangements, which is presented by a legal person or from the judiciary sector, we would like to take this forward and then to discuss that with the practitioners, and so that we know how it is being applied in practice, in reality, how they handle the cross-border disputes, and whether that there are challenges, there are problems that presents under this new arrangements. I would like to give a little bit of introduction of the three guests. First of all is Mr. Ho. Mr. Ho works in the divorce, the legal firm, and he works in the company, civil and financial disputes. And he has over 20 years of experience, and then he is very good at liquidation and bankruptcy, and then in particular in cross-border disputes. And then, Mr. Ho has taken on cases, and in fact serve as the expert witness in some of those cases. And then the other is Ms. Wang. Ms. Wang is a solicitor. She is the founding partner of her own legal firm, and mainly on the commercial, the estate property, and also the cross-border as well as local property and legacy arrangements. He is that qualified advocate. And then he also is qualified in practicing in the Greater Bay Area. He is the deputy chair of the Hong Kong Legal Society, and then he's actually served other public services. Lastly is Mr. Yu. Mr. Yu is the partner of Lam Yu legal firm, and then Mr. Yu is specialized in the blockchain and commercial law, and also the commercial transaction as well as cross-border investment. He has a qualification in the fintech. He also got qualification in Hong Kong, England, and GBA legal accreditation. He also served in Qianhai, and then he's a member of the Research Institute of the Greater Bay Area Institute. So without further ado, I would like to ask the first questions to Mr. Ho. And then just now we heard about the arrangement and the mutual recognition between the Mainland and Hong Kong. And Mr. Ho works mainly on the bankruptcy and the liquidation, and then he has rich experience in this aspect. So I would like to invite him to share his experience. Say, for example, if a company declare bankruptcy, and then if he need recognition from the mainland courts. And in the country, for instance, if there's a company declaring bankruptcy in the mainland, and then he wants to apply approval and then certification in Hong Kong, so what should they do? And then I think that Mr. Yu also have the respective experience. So how we would like to invite both of them to share the experience. So thank you, Richard. Well, as Richard said, the registrar just mentioned that in Hong Kong and mainland mutual recognition, in particular on insolvency and bankruptcy, the situation is still in process. So when we discuss it, we need to be very clear which area we need to focus. For liquidation and bankruptcy, we need to mention that because this is a very specific area. As you just note, and we have the mutual recognition mechanism, and then we have laws and ordinance in each and every area, but there is none in the area of bankruptcy insolvency. That means that in both areas we are applying a common law. So you might query why the mainland is using common law. The reason is, as what Richard said, is mutual. So in Hong Kong, if you have a proceeding in terms of bankruptcy and insolvency, and how are you going to get recognition in the mainland? And then, likewise, in the mainland, if you are in the process of liquidation and bankruptcy, how are you going to implement it in Hong Kong? So before I go into the mechanism, I would like to explain why we need this mutual recognition. And then mutual implementation. Bankruptcy and insolvency actually is not about the awards or the verdict. For the civil and commercial disputes, and then sometimes it involves an amount, whether that there's a penalty or that the accused will receive a certain writ saying that he's forbidden to do something. So if the accused has a certain jurisdiction in a home country that is not of the litigant, then they need the mutual recognition. But for bankruptcy, there is no accused. There is no implementation so far as it is concerned. Well, let me just say, talk about liquidation process. If you applied for the insolvency process in the mainland, then why do we need cross-border assistance? The answer is, in all the countries around the world, and I think that there is one basic principle. That is, if a company apply for liquidation, all the property or access need to be equally allocated. This is the basic principle, equally allocated, of course, according to the bankruptcy ordinance, to all debtors. So according to this principle, once you applied for that liquidation, then in Hong Kong, the liquidator
集去揾晒所有公司所有嘅資產，無論喺邊一個地方，都要集晒啲資產。如果係可以變賣、可以變現嘅，就要變現。咁集晒啦，先至可以公平分配。亦即係話，如果有人喺另外一個司法區，話我而家要去執行，如果你係一個債權人，你睇到公司喺另外一個地方入咗清算咯喎，公司喺度有資產喎，我咪馬上去執行咯。咁如果你執行成功嘅話，咁你就係有得益啦，因為其他債權人就冇啦嘛。咁就違反咗嗰個 破產法最基本頭先嗰個原則啦，公平分配。咁所以因為有呢個原則咧，因為資產都唔係喺一個地方嘅，所以咧如果公司入咗清算咧，就需要清盤官、清算管理人去所有關嘅司法區去揾晒所有啲資產咧，跟住調翻去公司清盤嗰個地方，跟住根據嗰套法律去公平分配。所以呢個就係點解喺清算嘅程序咧係需要咁嘅互認嘅。好，咁我講翻內地如果有清算程序，我哋香港點樣去協助？咁香港咧就同內地關於呢樣嘢咧係冇任何嘅法例嘅，亦都冇簽過任何嘅法例嘅，係完全靠普通法嘅。咁係點做咧？就我而家已經有5-6個 case 有咁嘅案例，就香港承認內地嘅法律，香港承認內地嘅清算程序。咁咧其實第一個案例咧就係喺2000年嗰陣嘅，就上海華信，咁咧佢就入咗清算內地清算程序。咁管理人入咗去之後咧，突然間發現，其實香港咧就有個判決，就係有個債權人佢喺香港攞到個判決，咁咧佢就要執行啦。咁佢執行乜嘢咧？執行就係因為上海華信咧喺香港有個應收款，咁就馬上要執行。咁如果佢成功執行咧，咁應收款就俾佢攞咗啦。咁佢攞咗，其他債權人就冇得分啦。咁對內地同其他嘅債權人咪好唔公平咯。咁所以咧，個上海嘅管理人咧就馬上嚟香港申請認可，要求法院認可內地嘅清算程序。咁好啦，認可係點咧？咁認可係一樣嘢，跟住協助另外一樣嘢嘛。咁你點樣協助咧？咁你協助咧個方式咧就係香港認可嗰陣咧，同時間會頒個命令，就話有關呢個公司所有嘅資產，同埋有關呢個公司所有嘅法律程序咧，必須暫停。咁暫停之後咧，就馬上擋住咗頭先我講嗰個執行啦。因為呢個債權人想去執行啊嘛，執行佢嗰個判決，對香港一個應收款一個判決，佢個執行個資產。咁你停咗一樣嘢咧，咁如果有資產，如果個應收款係可以變現嘅咧，啲錢咧就會俾翻個管理人，管理人就可以攞翻去上海，咁啊公平分配。所以呢個就係香港嘅機制。咁香港用咩機制咧？就用普通法。因為香港就唔係淨係承認內地嘅程序嘅，因為你係普通法咧，就全世界每一個國家嘅清盤程序咧，香港都可以去承認嘅。咁當然唔係話所有全世界乜嘢嘅清盤程序都會承認，係有啲因素嘅，即係有啲門檻嘅。咁其中一個門檻咧就係嗰個程序必須喺當地個公司喺嗰個當地咧係所謂嘅利益中心地。咁如果你過咗呢啲門檻咧，咁香港就可以承認，可以認可之後咧就可以俾相關嘅協助。咁呢個就係香港用普通法去協助內地嘅破產程序啦。咁你話係內地邊一個地方嘅程序咧？個答案就係全內地都得，冇分地方嘅，只要係內地嘅程序咧都可以承認，只要你過到嗰個門檻。咁好啦，就香港承認內地，咁內地點承認香港咧？所以我就話呢個就一個好特別嘅地方啦。咁2021年咧，最高法院咧就簽咗個意見，就話2021年開始有3個試點，就係廈門、深圳同上海呢個3個法院。呢個3個法院咧係有權 去承認香港嘅破產程序。咁其中一種破產程序咧就係清算，即係我哋叫清盤。咁都有個門檻嘅，都有你要證明呢個公司喺香港亦係一個利益中心地嘅。咁認可之後，又可以頒乜嘢協助嘅方式咧？咁嗰種協助嘅方式咧，就係基本上係跟咗聯合國個示範法嘅。所以呢一個咁嘅呢個機制咧係好先進嘅，所以係同世界接軌嘅。所以因為2021年我知道最高院簽呢份意見之前咧係做咗好多嘅工作嘅，咁睇晒全世界點做，睇完歐盟啊、普通法啊、英國法啊，跟住美國第15章啊，同埋呢個聯合國示範法嘅，所以係一個精華嚟嘅。咁簽咗咁嘅意見。咁有咗呢份意見咧，呢個3個試點咧，就個法庭咧就可以頒咁嘅命令嚟認可香港嘅程序。咁到而家為止咧，3個地方都已經有頒過咁嘅命令嚟認可香港嘅程序嘅。咁呢樣嘢係完全可以話係普通法嘅喎，因為大陸係冇法例噶嘛。頭先我話有個門檻，就係話呢個利益中心地。如果你即係我了解咧，如果你睇晒全內地嘅法例咧，你係揾唔到任何內地法例咧有提呢樣嘢嘅，叫做利益中心地。呢樣嘢咧係創造出嚟嘅，係一個世界即係根據世界標準嚟創造出嚟嘅。咁所以內地呢3個地方咧係可以承認。咁好啦，你睇翻香港內地個機制咧就係咁，香港係可以承認內地所有地方所發出嘅所有法院所發出嘅相關嘅重整，又或者係破產令，可以去執行，可以去認可。咁如果你香港去內地咧，咁你只可以去3個地方啫，就係頭先嗰3個試點。但係只要你喺內地攞到個命令咧，個認可之後咧係全國適用嘅，即係你唔係話如果我去喺上海攞到個命令認可我香港嘅清盤官嘅權力，咁我只可以喺上海有協助啫，唔係嘅，係全世界都通用嘅。即係我俾你一個例子，其實第一個案例就係咁嘅。就香港嘅清盤官向內地申請個認可令，咁喺邊度？即係深圳。咁攞到個認可令，攞到個認可令就話我咧就要控制內地相關嘅子公司，因為香港個主體咧就係冇公司，咁內地有子公司，所以佢要控制。跟住咧香港個主體咧亦都喺北京係有物業嘅房地產。咁所以咧，深圳頒咗嗰個認可令咧，係指明香港個清盤官咧係可以去控制喺北京嘅房地產嘅。咁所以你只要頒到個命令咧，係全國都適用嘅。咁所以咧就係呢個而家我哋嘅機制就係咁，暫時到而家為止咧，就係香港已經有好幾個案例咧，係承認內地嘅程序。當然唔係淨係話係清盤嘅，即係有啲案例咧，我都有參與過，係內地重整嘅。因為我哋話承認破產呢個咁嘅程序咧，其實好關鍵一樣嘢就唔係話清算，其實如果更加幫助最多咧，就係應該係幫助重整。咁內地咧，當然到而家為止都係承認咗香港嘅清盤，就未發生過承認香港嘅重組程序，就未發生過。咁呢樣嘢係可以再發展嘅。咁暫時我哋講到而家。
唔該晒，Luke，幫我哋探討咗就住呢個內地同埋香港 喺有關嗰個司法認可同埋呢個協助嗰方面咧，係有一啲實務上面嘅分享，咁大家都應該清楚好多有關嘅具體細節。咁我亦都而家邀請下 Karine 啦，咁剛才我都講咗Karine 同埋 Henry 咧都係考獲咗呢個大灣區嗰個律師資格。
Karine and Henry actually have the qualification to practice in the Greater Bay Area. Hong Kong and Mainland China have signed some agreements in deepening the collaboration between the legal sectors in Hong Kong and Mainland China. Karine will be sharing with us as a qualified lawyer in the Greater Bay Area how we can facilitate the development of the cross-border business. Hi, everyone. It's a pleasure to be here today sharing with you. I'm the second speaker. Well, let's do a warm-up exercise. Are any one of you a practicing GBA lawyer in Hong Kong or Macau? Okay, there are some. Is any one of you visiting Hong Kong for the first time? Okay, welcome. And I hope we can both learn something from each other. If you have been here before, and I still hope you can learn something new in the legal week or from my sharing. Because when I was preparing for this session, I was looking at the topic. It was long: legal services and juridical relations, and greater convenience, stronger legal protection, trade and economic activities, and social interactions. The whole context, under this context, how Hong Kong and Mainland China can interact more. So I thought to myself, should we start from the fundamental? When we are looking into this matter, we should think about what we can facilitate the construction of GBA. One of the documents signed in 2019, it was the GBA development blueprint. There is something I saw, and I want to share with you. We want to build a world-class city cluster and facilitate the development of Belt and Road Initiative and the 21st century maritime Silk Road. Actually, the Greater Bay Area is not a separate strategy.
It's not that we just finish off with the Greater Bay Area. It is nothing in silo, and the spirit is that it should be a foundation that supports other development of the country as a whole. So it's very broad, and then maybe that we should come back here. And then for this kind of development, we need the support of the country as well as from the provincial government. So what does it matter with solicitors and lawyers here? So I just start to think that, of course, we need to have social responsibility. And then, with that responsibility, we need to have business. So when we talk about business, it is not something existing in silo neither. This is a service. You need to have clients, and then as that client implied individual as well as companies. And we need actually to find our clients. And on the other hand, we know that we have SIPA. And then SIPA already identify who our clients are. So if we want to step out of our comfort zone, if we want to find new clients, then I think that we can take inspirations from SIPA. SIPA has been there for many years, and in fact, that it has been changing all along. And I also take note that last month is the 9th of October, 2024, there is an amendment about SIPA that is to establish a closer relationship between the mainland and Hong Kong. This is a service and trade agreement. This is a second amendment. That means that under the SIPA, that we need actually to continuously revise it according to need. And then with the second amendment, and then we talk a lot about judiciary, legal, and then liquidation. And then we talk about how to support the Hong Kong investment, applying Hong Kong law, and then to support the Hong Kong investment to choose the seat of arbitration. And then the amendment actually aims to provide more flexibility, etc. So that, these are quite familiar, but there's no details. But it's only last month that we put it into black and white. And then there are guarantees on the transparency of the rules of services, so that we can actually align with international requirement, and to streamline the process. To do business, there might be actually challenges along the way. So how are we going to solve those? Of course, arbitration is one way. The other is mediation. So if all in all, we all aim to promote the economy, and we can see that all this paper have indications all along for us to carry out our work. And also talk about new business. And then under SIPA, that in fact that they have lessened some of the restrictions on the qualification of companies that can be covered by SIPA. And before that, there's a restriction on having services for 3 years. Now that they have already removed that requirement. And we know that in China there are a lot of KOLs and different kinds of enterprise that in fact can be covered by the new amendment of the SIPA agreement. So personally, we know that the direction is always there, but the SIPA, in fact, also give us more support. Many people ask, after having the accreditation, what can we do? And my suggestion is that since we are all qualified lawyers in the GBA, so we should in fact explore and find opportunities within this new legislation. In the process, another question that I want to delve into is that I'm so lucky to have the opportunity to exchange with newcomers as well as the DOJs, and then I was invited by Mr. Lam actually to share my experience. It is indeed my honor. Well, actually, it enabled me to reflect that we are actually not working independently in Hong Kong, and then we are actually doing my business with our colleagues in the mainland, and we have the examinations to get our accreditations, and in fact, Hong Kong has these examinations open to lawyers from all over the world, as well as lawyers from the mainland to sit in this examination to get this accreditation, and so that they could practice their service, the practice in Hong Kong as well as in the mainland. And with this qualification, we can provide our expert opinion, of course, about our home country, as well as the situation, expert experience of the Greater Bay Area. So this is mutual. So whenever we have this examination, I always receive the questions about how to prepare for this examination. And likewise, we also ask opinions of our colleagues in the mainland, how to prepare for the examination. So that in this mutual interaction, we can explore more on our direction of development. We will be able to identify maybe there are new areas in the mainland, and maybe there are areas we want to develop, and we might learn more about the system in China, etc. So there are similarities as well as differences, and there are the space of collaboration and cooperation as well. And it is through this kind of dialogue and exchanges that we can explore more. So these are my personal sharing. And I also want to say that the intention of GBA is not just to develop the GBA, is actually having a bigger perspective with a bigger impact. And I think that GBA is actually having 9 cities as well as the Kowloon in Hong Kong. And then with this population, that we will need to understand better about the GBA as well as the country as a whole, as what looks like. This is not just actually for some particular province. It is applicable for the country as a whole, and with that we can exchange with provinces outside of the GBA. If we have no knowledge about the mainland, and then we don't really know how we can exchange and what we can communicate and explore when we meet mainland colleagues. So it is also actually beneficial for the both parties to explore the further space of development. So another impact is the radiation impact. So radiation is really expanding and very positive. So with that, when we talk about the one country, the two system and three jurisdictions, then Hong Kong is the only place within China that practices common law system. Then I think that we need to manifest it through the qualification of being a GBA lawyer. Lastly, my observation is that when we talk about, in fact, about the radiation effect, then we might, in fact, expand it to other Gulf area like the New York, California, San Francisco, and Tokyo Bay Area, and then to really contribute and then play a role in the development of the different Gulf areas around the world, and to find similarities and explore the space of development. Well, within my practice, in the daily practice, when we have more communications within this area, I found that colleagues within my legal firm, in fact, has been visiting the other cities in GBA more, and then they very often give me advice on where to go and when to go, and then what to find in this GBA area. And then we find that, in fact, the GBA is becoming more integrated, and that there is an increasing need in legal services, like the arrangement and also management of our assets, etc. So with more communications and people's flow, then in fact that more business opportunity could be created. So I will stop here because of time, and I need to leave time for Henry. Thank you, Karine. And we talk about GBA accreditation examination, and I think the Bar Association and the legal society actually encourage our young members to sit in these examinations. Well, some people might ask, is it very difficult? And then for us, we will say it is not. Definitely not easy, but it is not that difficult either. So we will encourage them to try, and then only after you try, you know how difficult it is and or how easy it could be.
So we would like to encourage more lawyers to take this exam and cooperate with the lawyers in mainland China to build on this opportunity. Now I'll pass the time to Henry to share with us, because in recent years, the technology has been influencing the legal sector, and a lot of people are talking about whether AI will replace lawyers. Well, Henry is also a technician in financial technology, so he would talk about how technology is related to the legal sector as well. Well, I know I don't have much time, so I'll just introduce a little bit about the background. I'm also a lawyer for over a decade. I studied in the UK. I was the first batch of lawyers coming back to practice in Hong Kong after the handover at 1997. So we saw the opportunity, so we came back to practice here. And the capital market was very prosperous since 2003. But of course, there were some setbacks because of the epidemic. Lots of lawyers served in in some international law firms, and afterwards they just come to the Greater Bay Area. So I went to an investment bank to become one of the staff. I learned from my then CFO and COO a lot about how to do business and the culture in mainland China, and I encourage you, the younger generation, to engage the Greater Bay Area personally by shopping, by visiting, or just entertaining yourself. I'm quite an innovative person. I find venturing very exciting. Let's talk about the exams first. After I got the lawyer qualification in Hong Kong, I was very eager to get the qualification for mainland China as well. I took the course at Big N, and then I learned that I don't think I can pass the exam while I'm practicing and studying. I have to study full time, otherwise I couldn't pass the exam. But earning my living is also very important, so I just paused this endeavor. But when the exam was launched, I participated in the first exam as well. And now I have my own firm, and I have about 30 staff at my firm. I strongly recommend and encourage them to take this exam when they accumulated 3 years of experience, because I believe in the near future, to be a lawyer in Hong Kong, you must have license in Hong Kong and in the Greater Bay Area, because you have to understand that the connection between Hong Kong and mainland China and the differences between the legal systems, you must understand thoroughly to connect your clients in both regions. Because in future cases, many of them will involve the legal knowledge and information between two regions. I can see a lot of lawyers are helping each other. When I was studying law, and when I was a legal student, there wouldn't be so much help from a peer and a counterpart. The second thing is cooperative firms. I also went to Qianhai to establish the cooperative firms. It's actually quite a good experience, because when I operate the lawyer firm in Hong Kong, it's very different to do the same in mainland China, because the contexts are totally different. And well, there are a lot of subsidies and supportive policies from the central government, and the mindsets of the lawyers and younger generations in mainland China are also very different. So no matter where you practice, I think you can learn something from your counterparts. First, I think cooperative law firms is kind of an arrangement very similar to marriage. And before you actually establish such a cooperative firm, I think you should give it some time to learn about the differences between the two regions. Now I will talk about AI as well. Committee member in the Lawyer Society. Well, AI is actually a very hot topic because we always worry about whether AI will replace us as lawyers in the legal sector. Well, in the short term, I don't think so because I've been using AI tools to review documents and the contracts. The tools can help us to review, and I can just ask the tool to give me a new clause if I am not satisfied with what it gave me initially. It is not a yes and no answer. In the short term, no, but we should invest into it. AI for all the legal firms in Hong Kong, it is very costly. It's very costly to develop an AI system. And the second thing is data, and the third is personnel, the talents. Because Hong Kong is rather small, and the data collection is not that economical. However, if we cooperate with some law firms in mainland China or establish a cooperative firm and develop an AI system with them, and it can take care of part of the tasks of the firm in Hong Kong, and that would make sense because a lot of mainland China firms have been developing their own AI system with big data. So you're actually participating and benefiting from their system and the process of development. Last but not least, I have to talk about business as well because we have to add. Okay, innovation. I am also a pioneer in blockchain technology. A lot of people thought blockchain has no prospect, but now blockchain technology is legalized in Hong Kong in 2023. And we have already issued licenses to three of the blockchain corporates. We have FinTech Week and the Finance Week. We actually we have a lot of companies are waiting to be licensed. Over 10 companies are waiting for license. There are lots of differences between Hong Kong and China, and there is something that you cannot do in mainland China, but you can do it in Hong Kong. A lot of requests that I received recently are quite surprising. We talk about real-world assets instead of crypto. Some real-world financial products. Before, we would talk about we have been helping the mainland companies to conduct IPO or and non-financing. Apart from the traditional capital market, and they would like to explore whether they can issue some real-world asset products in Hong Kong. First of all, they are thinking about whether they can split their revenue to create some new product like the charger of electronic cars, or whether they can use the ticket revenues of some tourist sites to produce some financial products in Hong Kong. I've been doing a lot of work in this area since 2018. In fact, this kind of business has been being conducted in a lot of places in the world. But when we're doing this in Hong Kong, we have to consider the differences between the legal systems of Hong Kong and mainland China as well. And we have to get the approval from SFC as well, and we'll need assistance of mainland lawyers to help us to complete this mission. If you have read about the news, Ma Yi has already disclosed some of the action plan of this kind of projects, and Standard Chartered is also considering issuing this kind of financial products, and Jingdong in mainland China as well. So the corporates in Hong Kong and mainland China are thinking the same thing. HSBC also issued the blockchain currency as well. Okay, the last words. Hong Kong lawyers should position as a superconnector and a super value adder. We should connect and add value for our clients. For new generations of lawyers, I would recommend them to visit mainland China more, not just Shanghai or Shenzhen. They have to go to different countries or provinces like Urumqi, Chongqing, Chengdu, and other big or small. You have to visit more cities, or in the Middle East and some Belt and Road countries. Don't just wait for people to invest in Hong Kong. We should reverse the process. We should find the opportunities in this whole chain. Okay, my sharing ends here. If you have any questions, we can talk about it later in person.
Thank you, Henry, sharing his practical experience, particularly in the crypto and in fintech. Many people worry about AI replacing human. And I think that we can make better use of technology, including AI, to enhance our business. So, in fact, that we still have some time. Well, in fact, that we should have Q&A time. I'm just thinking if you want to go to lunch or to have Q&A. Well, in fact, I receive questions from the audience, and that just is not directly related to what has been shared. There's an audience asking with the development of the country, if we want to nominate arbitration companies, and then who would you recommend? And then so I think that nomination is very good. and then whether that is from the mainland or from Hong Kong, that we have already been encouraging the development of arbitration in both places. Well, last week is the arbitration week. I also mentioned about how to make a better use of the regulations in the different jurisdictions. Whether that you choose to do it in Hong Kong or in the mainland, then I think that you really need to look at yourself first to see whether that you have really the strength of winning the case. We really need to work together harder. And I think that in all cases, whether that you choose the seats of arbitration, and then as long as you have qualified arbitrators, and that you abide with the international regulations and laws, or that the international companies is adopting the common law, then I think that maybe that the seat of choosing Hong Kong is more appropriate, then I think that is still questions that we need to explore. And then the simple answer to the question is good. And then I would like to take this opportunity, and also I hope that the discussion will enhance your appreciation of the cooperation between the two places, and then in particular with the cross-border and cross-jurisdiction cooperation. And then right now that we have more space in collaboration, and then that will, in all cases, contribute to the development of society and also the development of different business. And eventually, I would like to have a better development of the legal sectors in both countries.
Thank you very much, moderator and speakers. Thank you very much. Please get back to your seat. Thank you for your sharing just now. I hope that through the discussions just now, you have already got a deeper understanding of the opportunities, the one-stop services, as well as the legal services across the Great Bay Area. Ladies and gentlemen, once again, thank you very much for coming to the Legal Week 2024 on the discussion this morning. Thank you for all the speakers and the moderator for your moderation and kind sharing. Now it is lunchtime, as moderator said earlier. So please return your earpiece to the reception desk at the entrance before you leave for lunch. Please remember to take all your belongings with you when you leave. Please also scan the QR code and give us your feedback. For those online, please also fill in the questionnaire and give us your feedback on the session this morning. So for all those attended in person, if you need the CPD points or the points for the senior legal learnings program, please remember to register your name at the reception desk to record your attendance. Our afternoon session will start at 2 o'clock this afternoon. Please come back at 55, 1 o'clock. For those who continue to need CPD points or ALE points, please register your names at the reception desk before the start of the program. For those VIPs who have the colored tickets on the badges, please enjoy your lunch at the Longton area and follow our staff to the Longton. We're going to resume at 2 o'clock this afternoon. See you this afternoon.